Okay, so y'all want to move on to intrinsic acts. Okay. Which ones? Because there was a set that y'all said there just hadn't been a 403 analysis on yet. And then there was, I guess there were a few that at least somebody, Mr. Ryan was maintaining, were not really intrinsic.
Yes,
Okay.
Your Honor. That's accurate. Back in 2022, the state filed a general notice that they were going to introduce intrinsic evidence. We then got a witness list on July 31st, which I think was supposed to be one of the final, we can rely upon this witness list. And within that, there were 4 incidents which happened in 2023. So they, 1, post-date that notice, 2, they post-date the indictment. So we've never received any sort of notice from the state saying we are seeking to admit this as intrinsic. However, that is what it is labeled as on the witness list. So that those 4 are what we take issue with.
Okay, got it. And these are the incidents that occurred in the jail generally?
One in the jail, 3 in the courtroom.
Okay, thanks.
I'm not sure if Ms. Abbasi realizes that we did notice 2 of the ones that occurred in the earlier part of 2023. The stabbing of the person in the jail by Mr. Ryan, Mr. Blaylock, and others, as well as the violation of the Georgia Controlled Substances Act by Mr. Williams and Mr. Adams. And those 2 occurred on January 31st, 2023 and January 18th, 2023, respectively. The filing that we noticed the defendants of those on was November 6th, 2023. There were 2 additional acts that occurred in 2023 during the time that this case has been ongoing. And one was the drugs that were found in Mr. Stillwell's cell. And we've noticed some of the pictures of the drugs and the other contraband, and the marijuana that was found in Mr. Ryan's pants when he was searched in the courtroom.
Okay, so the stabbing, that occurred in the jail, right? Okay, and then the VGCSA violation was in court?
It was.
Obviously, drugs in Mr. Stillwell's cell was in jail, right? And then the marijuana in Ryan's pants was in court. Is there another incident that occurred in court?
Not that's on here.
Okay. Ms. Abbasi, you had said 1 in jail, 3 in court.
I'm sorry, Judge. That
2 in jail, 2 in court.
Correct.
Okay. And the argument as to each is that this is not really intrinsic?
Yes, Judge.
Okay.
It doesn't fall into any of the 3 categories which would classify it or qualify it as intrinsic.
Okay.
Here it is.
Let me pull out my case law on that. All right. What's the state's position on why and how that is intrinsic?
The Bussey stabbing, which is going, I'll start with, Your Honor, involved
I'm
Wisdale.
sorry, what'd you say? The what?
Oh, I'm so sorry.
I just didn't understand what you said.
Understood. The victim.
Love has been
in
so
the
soft-spoken
January
with the yeses, and I'm so
31st
sorry.
stabbing was
Okay.
Harold
All
Bussey,
right.
and that's what
Bussey,
I refer to
okay.
it as. So that stabbing involved several Wisdale gang members stabbing an inmate at the Fulton County Jail who was alleged to have messed with Rodalius Ryan's commissary. It involved, among others, Demise McMullen, Javon Fleetwood, Christian Eppinger, Damone Blaylock, and Rodalius Ryan. They all, in concert, held down this person and stabbed him repeatedly, all to protect and to vindicate something he had done to one of their fellow YSL gang members. It's the way that I
Okay.
see it. So that it seems just, it's what we've alleged in the indictment that YSL members do. They work to maintain individuals ready and willing to preserve and protect the reputation, power, and even the territory of the enterprise through the use of violence.
Okay, I understand.
With respect to the law, we would cite Johnson versus the state, a Georgia Supreme Court case decided September 21st, 2021, cite 312 Georgia 481. And we cited this last week. The Penn site is 491 to 492. In support of it. Okay. With respect to the January 18th violation of the Georgia Controlled Substances Act, this is 2 YSL members on trial for conspiracy to violate the RICO Act through drug distributions, drug use, drug possessions. And while in court on trial, they are passing Percocets, one to another. And we argue one to the alleged leader of YSL while in open court. One of the assertions that we make regarding the conspiracy. We have contraband in the jail. We have stabbing in the jail of YFN Lucci. We have communications in the jail. These types of actions on the part of the defendants are the type of actions that we have alleged in the indictment, and it shows that the enterprise flows from the streets to the jail to the courtroom, and that the conspiracy is ongoing.
And what exactly is the evidence you would be introducing on this VGCSA?
The video of it.
And what all does, I mean, maybe I need
The
to,
video
what does it show?
shows Mr. Adams going up to Mr. Williams while on a break. He's appearing to dap him up, if you will. Mr. Williams puts his hand up under the table. One of our lieutenants goes over to Mr. Williams and sort of says, "Give it here." Mr. Williams brings his hand out from under the table, relinquishes the Percocet to him, and later Mr. Adams is searched. And I think more Percocet pills, more drugs are found on Mr. Adams. And the drugs, the photos and
Okay,
tests of those drugs.
all right. And what's next?
The marijuana was also, so in Mr. Stillwell's cell, there was on March the 29th of 2023, there were drugs found in Mr. Stillwell's cell that consisted of ecstasy, pills, I think contraband, was it cell phone? A contraband cell phone, for him to have gotten those
Okay.
drugs into the jail while he's on trial for
Okay.
kind of actions involving narcotics and the enterprise and the sale and distribution of drugs through that enterprise. We believe is evidence of the ongoing conspiracy.
Okay.
Another,
And then the last one, I guess, was the marijuana found on Mr. Ryan. Give me a little bit more background about what your evidence is going to show on that one.
that Mr. Ryan, while sitting in court, I believe deputies may have smelled the marijuana
Okay.
on Mr. Ryan. And when they went back to try and search or to figure out where the smell was coming from, a large commotion was made. And the
By
deputy,
a large commotion by,
Mr. Ryan, and the deputies found the marijuana attached to, I think, his inner garments.
okay.
We have the video.
Okay,
Okay.
we don't know how it got there. I mean, on the Percocet, you've got an alleged gang member providing it, right?
Yes.
So how about, we don't have anything like that with regard to the marijuana?
We don't have
We
who
just-
provided him with the marijuana, no.
Okay. All right.
I don't know how pertinent it is that we have one that's not on here that is also involving drugs that are brought into the courtroom and provided to another YSL member, but that particular one has been severed, so we don't have that one
Right.
on here.
Okay.
Right.
I think that the first three that we talked about are, I can see how those would be intrinsic to showing the allegations that, this is a continuing, ongoing RICO enterprise. Mr. Ryan being in possession of marijuana when we don't know where it came from, that one, I just don't see that falling within. I mean, it shows, what it shows, that he's in possession of an illegal substance, but it doesn't, I don't think it's intrinsic. So I'm going to rule that one out.
Yes, Your Honor.
The other three,
Your Honor,
yes. Go ahead.
I appreciate the directed verdict that you just gave for one of Mr. Ryan's.
Oh, is that
intrinsics.
one of his, that's not something.
No,
that-
no, I'm saying,
Yeah.
you're
That's
keeping
not
it out
anything
without
that-
hearing, but from us. But regarding Mr. Stillwell's,
Mhm.
okay. We have an indictment with 100, I believe it's 191, could be off, 191 over X.
Yeah,
Okay, we also now have a list. At first we thought maybe they had abandoned these 53 and they were narrowing it down to 4, but no. It's 53 plus 4,
Yeah.
57 plus 191. That's 248, I believe. 248 uncharged events, or not substantively charged
Right.
events in that are coming into this trial. Regarding, the state keeps saying, and this shows the enterprise. Okay, there were apparently, I've seen photos, I wasn't there. There were pills that were recovered from Mr. Stillwell's cell, where he has a cellmate,
okay.
okay? There is absolutely nothing about those pills that suggest they were provided by anyone associated with YSL. There's absolutely nothing that suggests that those pills were going to anyone associated with YSL. There's absolutely nothing to suggest that any proceeds from those pills were being provided to anyone in YSL. there was a phone. I have not received any information from that phone that suggests any link at all to YSL. I am
Okay.
not saying my client's a drug dealer, but what I am saying is people that are in possession of drugs, whether it be my client or his cellmate or someone else, are able to sell drugs without being part of a huge enterprise and
Mhm.
without any evidence that somehow this is linked to YSL. This isn't intrinsic. The test for intrinsic is an uncharged offense arising out of the same transaction as the charged offenses. I don't believe that's the case. Evidence necessary to complete a story of the crime. That is definitely not the case in this scenario, and it's inextricably intertwined with the evidence for the charged offense. I don't believe that's
Right.
the case either. So
I wish he
I
led with
don't know
this.
why
I wish he
this
started with it.
understand. Thank you
and he
for,
is, and just so you know, Your Honor, he is charged on a separate indictment. I believe it's indicted. If not, it's in a CP case still, but he is charged separately, and that case is pending in Fulton County Superior Court.
okay, appreciate it. Thank you for bringing my attention to that.
Your Honor,
Yeah.
if I may a bit further, the one case,
On which?
really regarding all three of them. I'll
Okay.
start specifically with the stabbing as the state did.
Can I rule on this other one first? Give me just a second.
Which other one?
The one that Mr. Schardt was
Stillwell.
just
Yes,
talking
Your Honor.
about. Okay. So the Stillwell had a cellmate. Is there any evidence as to where the drugs came from, or that it was his, or that the cell phone was his, or connected in any way to YSL?
Well, two things. So yes, we believe that, I think we have, do we have body cam research? We believe that the testimony from the deputies within the jail would establish his ownership of it, but more importantly, what we have, I briefly touched on it, was the other YSL member whose intrinsic act that we've not put in here. The pills,
Mhm.
if we call them purple hearts, blue stars, and yellow diamonds, they were trafficking amounts in Mr. Stillwell's possession, and they were trafficking amounts in the other YSL members' possession. That is not on here and that has been severed. They are the same type of pills, and they are a large trafficking amount.
Okay, but
And we know that at least that other one, that
Yeah.
other YSL member smuggled the drugs into the jail, or at least into that area, through the courtroom. As it was described, it was enough in one, it was a pharmaceutical.
okay, so any evidence that what was in Mr. Stillwell's cell came from that?
Other than it was that they were just alike. If you looked at photographs of it's not like you had all white pills. Like you had the same array,
Blue,
variety,
purple, and
to use just some colors. Like they were literally at least three different colors and three different shapes of pills. And they were the same, three different colors and three different shapes.
and you can establish that those were YSL related?
Yes, because, yes,
How?
when you say those, you're talking about the one?
So
that
if
originally came in?
I'm to accept that y'all have enough that you can make the assertion that the pills that came through some court proceeding to this other person who's not a part of this trial,
Right.
are the same that are in Mr. Stillwell's cell, then what's the YSL connection?
Not the
there?
same pills, the same,
Type, the same,
Yes.
shipment or whatever, the same
that person,
loop.
that person was in this trial. That person was in this trial during that time.
Okay, but them being in the trial and co-defendants doesn't establish what the assertions are.
No, it's the not similarities, the exactness of the, like,
No, I'm not asking at this point, like, assuming for the sake of argument that, yeah, these pills all came from the same place. And he, in fact, then what's the YSL tie-in?
may we approach with a member of the defense?
Sure.
Are we approaching? Look at them talking. Look at them talking. Hilton looks like she's like, why would you do that?
I didn't know y'all didn't have them. They're not up here. Yes, you may.
Thank you.
So are y'all satisfied about, our other bench conference was about the location of that other person? Everybody, I just assumed that y'all.
Okay, are they muting? We're not quite at the bench yet. Love is still trying to figure out her argument. Look at Hilton. Hilton looks annoyed. Oh my god, this is your bench conference. And you're the one that hasn't approached. Look at Doug looking over. Yeah, it is like a doo-doo-doo type of moment. So they'll still do like bench conferences to keep it off the media. Maybe it's private information or who knows what. Maybe it's just an argument that Love doesn't want on camera. And then Gil had said earlier, judge always leads the state. Will you use it for recollection or for impeachment? Which Love repeats. Love just echoes back what the assist from Whitaker seems to be. Let them answer for themselves on objections. To be fair, if you want this trial to move along, you might need to give Love the assist. The downside, right, if we don't let Judge Whitaker give the assist, we might just have Love buffering indefinitely for minutes, hours at a time. But it does seem like, especially today with pretty much really any of those social media posts, and some of the stuff with the Yak statements, the Yak interview, Love was just on pause. The judge looked over and was like, well, what are you going to say? Are you going to say this or that? So you're exactly right, Gil. But yeah, the other side, the alternative would be just to let Love stand there and try to think of something. So you got to pick your battle. But it does seem unfair because the assist isn't happening in the same direction for the defense. And that's not to say the defense doesn't know an argument that they want to make, but sometimes when Schardt starts talking about things that are more theoretical and descriptive and doesn't jump right to the basis or to the law, the thing that Whitaker seems to want to hear, it would be nice if she at least tried to assist and cue them the same way she cues the state. She could balance that out a little bit, but she doesn't. Thank you for the super chat. Same thing, Nika. Thank you for the super chat. And then Chloe Albert's Revenge says that by Love's standard,
All right,
her
and
Avon
with
lady's in a
regard to
gang.
the Contraband in Mr. Stillwell's cell, I'm gonna rule that out as well.
Okay, nice win
and, I mean,
for
we may have another
Schardt.
Indictment against him at some point in time, and it would all be appropriate to come in there, but not for this case. So that, now, Ms. Abbasi, what do you want to say with regard to the other two?
Yes, Your Honor. Your Honor, actually, the state cited when they discussed the stabbing, the same case I cited, Brown, which had, as Mr. Schardt said, those three circumstances. Uncharged offense, which arose from the same transaction or series of transactions as the charged offense. That's actually the topic of discussion in Brown. And in Brown, it was a robbery which happened 1 hour before the charged crime. If the state is going with it's part of the same transaction or series of transactions, then we have a very serious problem with proximity, because the case law is not anything a conspiracy does that happens over the lifetime of the conspiracy qualifies as intrinsic, it has to be closely linked with the others, closely linked with the other charged offenses within the indictment. Your Honor can look at Sanchez Villa versus State, just 341 Georgia App 264 from 2017. Within that case, the evidence the state was trying to present, the court found all of the cases the state submitted distinguishable. And the same is true here when Your Honor goes through the cases as far as being part of the same transaction or series of transaction as the charged offenses. This, like those cases, is attenuated in time. For ones which do have more time in between, they discuss how in those cases, the defendants in their other uncharged acts were in the exact same role. So in one, it was trafficking cocaine as the lookout. In the uncharged, trafficking cocaine as the lookout. There were very specifics linking them.
Were any of these in the Sanchez Villa, either those facts or the cases that are distinguished, either a RICO charge that was involved or a gang enterprise?
I will double check because they go through quite a few cases. I'm going to have to look back through all of them. I think the hallmark of it that we get within Sanchez after they discuss all these cases, the evidence in this case, the Sanchez case, is considerably more attenuated in time and space from the events leading up to the charge offense. So it offers little to help the state. They continue on and say that, well, as far as this goes, we're not in a circumstance of completing the story of the crime. This is just expanding it.
Yeah,
completely.
Right. It's a different crime, but it might have been a different thing if they were charged with a RICO count in Sanchez. So that to me is what, if these were just whatever the other charges in the indictment are, then I would say, no, but it's the kind of enterprise nature and the ongoing nature that.
And I certainly understand that, Your Honor. I think, however, to say, well, it's part of the conspiracy basically opens the door to anything any defendant allegedly who is a member of YSL does, then automatically becomes part of the conspiracy and automatically comes in simply because it is intrinsic. I think with a lot of this, Your Honor, we're getting close to some due process concerns here. The defendants are on trial for the offenses they were indicted of. That's what they're on trial for. They're not in trial for the enterprise continuing in 2023, that it was still ongoing. That's just not relevant. If the day after indictment, every one of the defendants got together and said, whatever our group is over, and it was completely disbanded and no longer continued to exist, that wouldn't be relevant either. What they're indicted for is what they're on trial for. So here we're expanding. That's, I think, a lot of what's happening with our social media and other things that I guess the state has found afterwards. They're now being tried for things the grand jury never heard about. And that specifically is a violation of due process. I can supply to Your Honor the U.S. Supreme Court case law.
No, I'm with you on that one. And I am very skeptical of the state's argument that any uncharged, not showing up in the indictment overt act that they offer could in any way support, if found, a RICO count being
I wish we could see the
established.
state
So
right now. I wish we could see their
unless I hear
face.
otherwise, which I don't want to hear otherwise right now. We'll take that up another day, but that's not our issue right now. But yeah, I think the state's got some convincing on that count. But with regard to whether, it's intrinsic, I want to get it right. I want to follow what the law says about it. So I think that the key issue here is, if we're talking about RICO or we're talking about, a gang enterprise kind of thing. So maybe we could all do a little bit more research on that.
I did look at, in the state's original notice, they cited a proposition, I believe that was cases have been in gang and conspiracy prosecutions. Gang and conspiratorial activities have been classified as intrinsic evidence. They then cited a number of other cases.
Mhm.
There is not one single case I can find in any case at all where the intrinsic actions come after the indictment, because that's the touchstone of it being intrinsic, that it really is all one thing, that the story doesn't make sense without all of these pieces. And these things hadn't even happened yet.
Yeah.
So it's not possible
Let-
that they could be essential.
Let me ask you this. If, for instance, and this is entirely a hypothetical,
Yes.
but if this group got together and stabbed this, whatever his name is, Bussy, not because he messed with Mr. Ryan's commissary account, but because he was going to be a key witness in this case. And I'm sure the state, if in this hypothetical, would argue we're trying to send a message that he better not be a key witness in this case. Would the argument be different then?
Well, yes, it wouldn't be, they wouldn't be trying to admit it as an intrinsic act. It could be a crime in and of itself
No,
separately.
no, we're not talking about then they get separately indicted. We're talking
Right.
about they're in the middle of this trial. This happens. It's not obviously set forth in the indictment because it
Right.
just happened.
It would be 404B and probably fall into a category there, which would make it admissible for a basis which was not character. It just wouldn't come in as under intrinsic.
Okay, so you would still make the same argument that it was not, that it couldn't be intrinsic evidence, even for that, because it occurred afterwards.
Based on the definition I've seen of intrinsic, I don't think it's possible for something which comes after to be
Okay.
necessary to complete the story, unless the story wasn't complete at the time of indictment. But that's fundamentally unfair to try them for something which hasn't happened yet.
Okay, they're not being tried for it. It's,
Correct.
but okay.
Based on your
All right,
example.
well, I mean, y'all try to find me some more on point law on both sides, please, if you could. So
Yes.
maybe that'll be my preliminary ruling, subject to revisiting, okay?
And Judge, there was one other thing. I don't know that it'll have any bearing on the court's ruling, but in that instance where Mr. Stillwell, where the drugs were found in Mr. Stillwell's cell, there
Mhm.
were, Miss Hilton pulled up the photograph that I asked her to, and there was a shank.
Is the shank inscribed YSL? Then it
No,
doesn't, I
no.
mean, it makes Mr. Stillwell look bad, but it's not intrinsic.
Yes,
Okay.
Your Honor,
Yes.
if I may,
Yes.
before you make a decision on the one alleged intrinsic act that was referenced by the state involving the supposed passing of a Percocet pill from Mr. Khalif Adams to Mr. Williams, I would ask that the court at
Clarify the
least
other
go and
Adams.
Take a look at the video that was referenced by the state. I think it's instructive. I also think that well, fortunately for us, paints a different picture than was recited by Madam Prosecutor. I think the events did not occur in the manner that she referenced. I was present. I was sitting right next to Mr. Williams. I think the video will show something being passed to Mr. Williams, not him hiding his hand underneath the table or bringing it out and then giving it to the deputy, or the deputy saying, give it here. It didn't happen that way. And I think that goes into the analysis of exactly what happened.
All right, why don't you just tell me what you recall or what you think the video shows?
Sure. What I recall and what I know happened, because I was
Okay.
sitting right next to Mr. Williams in the front of the courtroom, is that there was a break. Mr. Adams, who was sitting in the rear part of the courtroom, came up, and as he was going towards that door, goes as though he's going to give Mr. Williams a high five or a dap or something
Right.
like that, and put something in his hand. There's a deputy who's standing about 2 feet in front of Mr. Williams. Mr. Williams looks surprised. Mr. Williams has it in his hand and puts it down on the table immediately. There is no putting hand under the table to try and conceal it. The deputy, who I was within earshot of, did not say, give it here. Mr. Williams looks at it and puts it down on the table, and that's it.
Okay.
At which point another deputy sees Mr. Adams and either takes him, I don't remember if they took him in the back or brought him back here.
Okay.
He was searched in the back, as I understand it. I think court recessed after that because of those occurrences, but that's how the incident actually occurred.
Okay. Can y'all send me that video?
yes, and
Okay.
the deputy, the lieutenant, would also be a witness.
Okay.
to what I'm saying.
All right, well, I mean,
The version
I would
I'm
imagine the video shows what happened. So.
It does.
It does indeed. Speak for
All right,
itself.
well, we'll come back to those two. All right, so that takes care of the allegedly intrinsic, but according to the defense, can't be intrinsic because they happen later in time than the indictment acts. What about the other intrinsic or allegedly intrinsic acts that there has not been a 403 analysis on yet?
Can I just add something to the last? Your Honor, can you ask what the prosecutorial need for this is?
I can, but with intrinsic acts, that's not part of the analysis.
Yes, 403 is the
Well,
analysis.
403.
You need a balancing act.
Which
So-
Yes,
includes
you do.
prosecutorial need, waste of time, prejudice, substantial prejudice outweighs any probative value. But to me, this is a big case. It's
It
been going on a
is.
long time, and now intrinsic acts. So yes,
Okay.
I don't know how much the state needs to prove that Mr. Williams was knowingly or unknowingly given an alleged item. I'm not so sure the crime lab came back, but I can't answer for that.
Has the crime lab come back?
That may be true. I don't know. I don't remember.
Okay. All right, so we now have a 403 argument or objection.
So, Your Honor, I think that the court had it right regarding the need to analyze, looking at the prosecutorial need. If it's a 404B act, then that would be a situation where we would be looking at the prosecutorial need, but it's not. We're alleging that it's an intrinsic act. And looking at 403, Your Honor, the analysis is it substantially more prejudicial than probative? And it's simply not, is our position. He's alleged to have, Mr. Williams and the other indictees here are alleged to have conducted drug transactions. One of the acts on the indictment involves
Them having a trafficking amount of drugs, right?
at least one. So we would argue that it in no way can be viewed as substantially more prejudicial than probative, and it's intrinsic. But we're pulling up the video too.
Well, I mean, I guess is that intrinsic is yet to be determined based on the time period, but
Your Honor, this is
Yes.
not really my argument, but I have got to weigh in here
Oh,
on
please
this
do.
issue. Yeah, thank you.
Go, Doug.
I'll get my 5 minutes in. The 403 analysis is not limited, as you know, to is it more prejudicial than probative? As Mr. Steele said, you also have undue delay and waste of time, and those are factors
It's
as
like my
well
motion.
that I'm not surprised that the state ignores, because they seem to have no concern for delay or waste of time. So those are factors that the court should consider as well, Your Honor.
all right. Thank you. Okay, well, I will
Keep
give y'all
pressure
a
cooked
couple of
there.
days to, if you can find more on point law, provide that. And if not, I'll just have to go on what we've got and make a decision. I'll take a look at the case that got cited and the cases within that. And then if need be, do the 403 analysis. I may not get to that, but okay. So that's those. What about the other intrinsic acts that 403 hasn't been done on yet? Do y'all just, is there a list? And is it? And I can't, let me see who, I'm not sure quite who filed that one. Or maybe Mr. Schardt just told me there are some that the 403 hasn't been done on yet. From the November 6, 2023 filing, but I don't know which of those.
And some of them have already been, so the Judge Granville made an initial ruling
Right.
on one day on 1 through 3. And then throughout the trial, we dealt with and admitted evidence on number 4.
So now
Is-
Glanville's
not right
ruling
in
should
front of me.
What
stand.
list you're referring to?
The
Is it-
filing on November the 6th, 2023.
Yeah, I think
Of
I've
the-
got that. Give me a second to locate it.
And thank you to Good Vibes and for always, forever, for life for becoming members. Glad to see you in green.
Okay, yep, I've got it.
So, Your Honor, my recollection is that we began discussions on this one day a long time ago.
Okay.
And I agree with the state that they have presented evidence on some of these incidents, some of these acts. Your Honor is saying that we haven't done a 403 analysis. I don't believe
Only
we've done.
because y'all, that's what I thought you had said to me.
Okay, if I said that, I believe I misspoke. I don't believe
Okay.
we've done really any analysis on this list. Meaning,
Okay.
I don't believe, speaking for the people on this side of the room, I don't believe that we are conceding that they're intrinsic.
All
and
right,
get-
so we
get into
may
the
need
403.
to, starting with number 5, look at all of them.
Like, Your Honor, I thought we were going by the state's July 31st witness list. So that would not encompass all of these things on here. That witness list went through by what offenses it was set to
Oh,
prove or
this one?
acts. Yes. So I was relying on the witness list when filing motions in limine of what they actually intend to prove. I thought that was the whole purpose of,
Well,
Judge, I'm not sure if Ms. Abbasi, we filed this November
Yeah.
the 6th of 2023, and I know she wasn't here at that time, but we, this is the argument I think that Mr. Schardt made. This is the one that he sent out with his objections. This is the
Mhm.
filing, so this is the one that we're addressing.
okay, well, I mean, if for instance, you're not gonna, you don't intend to use, 20 through 30 anymore, tell us that. If you still think you intend to use every one of them, tell us that.
A lot of them have already been completed, and there have
Okay.
been testimony, there's already been
All right.
testimony on a lot of them.
Okay, so can you tell me right now?
Yes.
Which that's true for?
Number 4, the 5/12/2013 aggravated assault and home.
Yeah, I mean, I've got it right in front of me, so if you just want to say number 4, that's
Number-
fine.
Number 4, number 5,
And you said a ruling had already been made on 1, 2, and 3?
yes.
Okay.
We didn't admit them, but they were. Okay, so we did not admit evidence of 1, 2, and 3. All that we did was address them initially. We didn't admit evidence, and we don't intend to, but those are the only 3 that were addressed initially.
And you don't intend to, so you're not intending to introduce those 3?
Right.
Okay, well then we'll cross 1 through 3 off the list. Okay, 4 has already been admitted, 5 you said has already been admitted.
Right.
Now what?
Also, as it relates to 7, 7 is one of the overt acts listed. The reason that we included it here is that Shannon Stillwell's name was not in the indictment itself
Okay,
on that overt act. The same as to number 8. What? I said the same as to number 8.
okay, so those are listed, those acts are listed as overt acts, but Mr. Stillwell is not listed in the indictment when
Right.
you're talking about the overt acts. Okay,
Correct.
all right. What about 6?
6, actually, so 6 is gonna be talked about. It has already been talked about
I thought so.
some, and it'll be talked about some more.
Yeah, I thought it had already been talked about some. So I mean, that's in the past, basically. 7 and 8, given that they're overt acts. adding Mr. Stillwell to them, that can still come in as intrinsic. What else?
10 has already
How about
been,
9?
9 has not been talked about.
And do you intend to still present evidence of that? I mean, you do at some point need to streamline your case.
So we can strike off number 9.
All right.
I believe. Ten and 11 have already been alluded to, and in fact, 11 has been discussed by the witness who's currently on
Okay,
the
so
stand.
those are already in.
Yes, and I think that the court at first asked me to tell the court which ones that we had
Well, you
already-
know what? Why don't we just walk through them the way we're doing now? Because you might decide on some other ones that you don't need those.
All right. So Hill Street there will be testimony given on that through Detective Dennis.
Okay. And
Oh,
who's
he already
involved in
talked
that?
about it. Ms. Hilton has
Okay,
reminded
so
me.
that's already in also. Okay.
Number 13, a witness has already talked about,
Okay.
Mr. Copeland on the stand. Number 14 has already been testified about.
Okay.
We've taken off number 15.
Okay.
Number 16 has already been testified about. Number 17 has, we've already presented evidence on.
Okay.
Number 18, we've already presented evidence on. Number 19, we intend to present evidence on.
All right. And tell me, is that like part of the gang rivalry leading up to Mr. Thomas's? I mean, I'm just looking at the date for that, or why is that intrinsic? Why is that a part of the whole story?
Already.
We've talked about it, or y'all have talked about it.
She's right. We did.
I'm not aware in
The aggravated assault at Trestle Tree on the 8th.
what case is that?
The aggravated assault at Confederate Court,
I'm aware of that, but
through Detective Dennis. I believe that when he gave, I'll have to go back and make sure, looking at our, at the flip chart that we made while he was on the stand.
Okay. But would this be part of the back and forth that y'all assert led up to?
It was part of the, yes, part of the shootings that they went back after the murder of Donovan Thomas and found out about. So that when we say back and forth that led up to it, they
Uh-huh.
started investigating those shootings after the murder of Donovan Thomas. And
Okay.
this was one of the ones that
And this is a shooting of whom by whom?
at Trestle Tree, which would have been if gang territory, we allege by YSL members. but
Okay, and what evidence do you have of that?
We did. Okay. So, and just so that Mr. Schardt has that, it's for 150080094. We've already put the CAD report and the 911 call in.
okay.
Okay, well, that pretty much
Well-
sounds like that's in then.
Well, I don't
Okay.
agree. I mean, what's I think obvious right now is I've been very involved in this case.
Mhm.
I don't know what this January 8th shooting is. I'm asking Miss Love. She doesn't know. So I'm trying to figure out how anyone could argue, if no one even knows what it is, how it's so intrinsic to this case.
Yeah, I don't know if she doesn't know what it is.
Well, I mean,
period,
I keep
or if
asking,
She
I'm
just
giving
doesn't
a-
know right now what it was. So who is alleged to have done this?
So
Or is this just a general, we, the gang experts, found out about this and we think this was a part of it? It's so, okay. Is there gonna be more besides what's already been
no,
testified to?
No.
Okay, so it's already in. Okay.
Okay.
number, what number?
20.
20. We have already heard testimony on this one.
And that's all we're gonna hear as to that?
Yes.
Okay.
Yes. And we've already heard testimony on 21
All right.
and 22.
Mhm.
We're not introducing 23.
Okay.
24, we've already heard testimony about, and we will hear more. This is actually where we got that video from that we mentioned. Mr. Sledge, that's in the folder for Mr. Sledge.
Mhm.
Number,
So, hang on. What else is gonna come? I mean, great if the video happened to be from there, but what else is gonna come in about this ag assault criminal damage?
well, Antrivia Smith is one of the witnesses that we've listed,
Mhm.
and her testimony.
That's a victim?
Yes, that's whose
Okay.
house it was.
All right. Okay. Go ahead then. 25.
This is January the 28th.
And then Delicates of Life, I'm not sure who Nikki Barnes is. So I missed the context of your comment.
I thought we'd already.
So back to the blue magic in the pills.
Kendrick.
But I didn't know who Nikki Barnes is by name.
$15.02.
There we go. There we go. Thank you.
Back to 25, 20.
Okay. That's fine.
26,
Oh, another movie for my list, you guys.
introduced evidence of. 27, we've already introduced evidence of. 28, we've already introduced evidence of. With the exception.
And FFS says we're running on.
Hilton is reminding me that with the exception of Shannon Stillwell's involvement in the Little Wayne bus shooting, it has come in, but it was added here because Shannon Stillwell's name was not on the overt.
All right, that's fine.
That love is running on Windows XP with dial-up.
29 is coming up. The shooting at Club Crucial preceded the shooting at Adele Drive and Drew Drive, and that's duplicative of 7 and 8. So 30 through 33 are the same.
So, I'm sorry, 30 through 33.
Yes, I was saying 7 and 8 if the court would just.
Oh, okay. So they're just listed on here twice, basically.
Yes.
Okay.
34 is already.
So I can just cross off 30 through 33, right? Because we've already covered them. Okay.
34 has already been testified about.
Hey, did the prosecutors have to do their training this morning?
Okay.
Was that why they were late?
36, we don't, well, actually. I asked the court to allow us to come back to 36. I believe that there are ruling may have been made on that.
Okay.
At first,
Right.
I want to check. and make sure. 37's already been testified 39, we don't intend to introduce evidence of.
Okay.
40, we do intend to introduce evidence of.
Okay. That seems pretty intrinsic.
We were taking off 41, Mr. Mender is in 7. Wait a minute. Oh, Judge, I
Yeah.
apologize. As far as 39 comes in, I was thinking of another incident. 39 is coming in. That is what led to the arrest by of Mr. Kendrick and Mr. Arnold with the firearms that Mr. Kendrick entered a guilty plea to that involved his plea colloquy that we spoke about earlier. But the fact that Mr. Arnold didn't want to identify Mr. Curtis or testify against him at trial is not, we're not putting that part in.
Okay, but that Arnold was assaulted by
By
that
Marquez.
you want to have come in? Is that what you're
Yes,
saying?
yes, yes. That is what led up to the arrest of Mr. Kendrick and Mr. Arnold. They went to retaliate. So my apologies. That's 39 and 40 coming in. 41 being taken out. 42, we don't intend to introduce evidence of 42.
Okay.
43, we do intend. 43 is coming in. Well, we intend to introduce evidence of 43. That's tied to the armed robbery that he's alleged in the indictment to have committed
Okay.
on October the 11th. 44 comes in because that, we believe, is the motive for the murder. That is the last murder on our indictment.
Okay.
45 similarly is tied to the Chamel Drinks murder. So we would argue and would ask that that be allowed to come in. 46 as well is tied to the murder of Chamel Drinks. As a matter of fact, 47 and 48 and 49 are all tied to that murder. So the ones that we've listed as intrinsic that the court has heard us talk about, for the most part, 90% of them, I think, are part and parcel of acts that have been alleged in the indictment that just didn't include certain aspects that are now listed on this supplement.
All right. Yeah, I mean, there's not a whole lot. Well, what about 50 and 51? Those are the
two
ones that we just talked about. Okay. All right. So other than those two, I mean, honestly, most of it already has come in, or is like, I don't think even arguably not intrinsic to the rest of the crimes and overt acts. So I think the rest of these, not 50 and 51, but the rest of them, unless you've got some kind of a 403 argument to make, those seem appropriately in. Okay, so sounds like that settles that.
Yeah, I was gonna
other
say
than
no
those two
objection.
Subsequent acts.